aside from how do I get my money back for a cancelled holiday or wedding or another event just like that, the most common questions I've received during the pandemic have actually been, what are my rights when I'm on police bail or when I've been released under investigation, which lawyers sometimes refer to as RUI. Now, criminal, as you know, is not my first specialty. So I've called upon two of the leading lawyers in the area, Barrister Nicholas Rhodes QC and Solicitor Simon Hancock, to help answer some of your questions. Simon, I have a question here from John, and he asks, I was arrested under suspicion of a drug-related offence. I was released on bail on the 10th of March. On the 27th of March, my bail was extended by a further 28 days. Will the police have the right to keep on extending my bail?
The answer is yes, the police can, but eventually they will end up in court having to extend his bail. At that point, the court will consider their investigation and whether it's been acted with due diligence, and then they could decide, in fact, not to extend his bail, and therefore the police would then have to decide whether they are going to charge John or release him under investigation.
How often does that happen, Simon, where the police get to effectively the end of the road, so the court no longer will allow them to extend, and they then decide, oh, we'll just flip over to release under investigation? Is this common?
It's becoming more common, yes, and it's a concern, because the police could have almost had a year having a suspect on police bail, and then suddenly, when the court has said enough is enough, you really should be in a position to charge this suspect, they then decide, actually, we're going to release him under investigation. And normally it may well be because they haven't been able yet to have any of the items, for example, computers or mobile phones, examined and interrogated. And that's normally the reason when the police say, we need more time, and the court says no, and so therefore they revert to releasing that suspect under investigation.
I have another question here, this time from Sean, and he says, or he asks, I was released on bail after being questioned about drink driving. I wasn't given any paperwork, so do not know if any conditions were added to my bail or what the bail date is. What should I do? Nick, sounds like a strange one, but what would you do in that situation?
Well, I think the obvious thing for him to do is to get on to the police station at which he was questioned in order to obtain the paperwork that he hasn't been given. It might be the best thing to do is to contact the custody desk. I don't know if he's got his custody number, but he can certainly give his details, and they should be able to trace him within their system, and they would then be able to give him the answer that he needs. But I do find it a little odd. He would ordinarily have been taken into the police station if he'd been arrested for drink driving. He would have blown into an intoximeter. That would have printed out a result, and he would ordinarily have been given a copy of that result. And then when released, he should, as he seems to suggest, have been given paperwork, not least to tell him whether he was due to return at a particular date, or what further action he should be taking, or what conditions attached to any bail. If he's in any doubt about what he should do, the best thing is for him to get hold of a solicitor. He wouldn't, I suspect, get legal aid. Simon could probably help you with that. But I doubt he gets legal aid for drink driving, but he may have to pay for that himself.
Lots of the questions that I've been receiving as well are people saying that they're on bail, but it's all gone silent and they have no idea what's going on next. Of course, there are time limits, but can the police just go silent? What happens next when you're put on bail?
Are you talking about police bail or released under
police bail?
Well, on police bail, then normally a suspect has got representation, and it's their lawyer who would be in contact with the officer in the case, prodding that person, asking them where they are with their investigation. So that is really where any suspect should look towards, first of all, is their lawyer. If they don't have one, then the officer in the case would have provided them with their contact details, and the suspect should be phoning the officer for an update, and do that on a regular basis. is my advice.
Nick, Simon explained at the start that when the 28 days are over, there are certain procedures to go through with extending bail, and eventually the police have to end up going to court and asking the court to grant an extension. In your experience, what's the attitude of the courts? Are they pro-police or pro the accused? What should one expect when they get to this stage?
Well, they're not pro either side. That's not the duty of the court. The duty of the court is to examine the material that it has in front of them. And in the case of this type of inquiry, to see whether the police have acted with expedition and diligence. And what that essentially means is, are they getting on with the job? If they're getting on with the job, then the courts will reflect that in the decision they take thereafter, respecting either the continuation of conditions or the need for conditions, or the need for bail at all. So it's not the job's court to support the prosecution or indeed the defense, but it is the court's job to review the material, to permit the prosecution, if it's appropriate to do so, to continue to hold a defendant under conditions of bail, and or to review those conditions and protect the defendant from, at the same time, from a police investigation or other investigation that isn't proceeding with due expedition and care.
So obviously in 2017, we had the big changes to bail, which put in place this 28-day rule and the other provisions that are now there. And my understanding is, since we've had this, we've had less people put on bail, but more people released under what we call released under charge, or I think you guys call it RUI, I think it's more commonly referred as. Simon, what's the difference between RUI and bail?
Well, released under investigation means there aren't any conditions attached to whilst the police are making their diligent inquiries about their investigation, whereas police bail conditions can be attached to that, which you have to abide by.
Now, of course, unsurprisingly, because there's more people who are released under investigation than bail, there's lots more questions on this. Wendy asks, I was questioned by police in December in relation to an alleged fraud. I was released under investigation and have not heard anything further. Why was I not put on bail? I'm not sure why she's asking about that or complaining about that, because I think it's better to be RUI than bail. But Simon, what do you make of that?
Well, it may well be with her particular case. Frauds are particularly lengthy investigations. They normally involve telephones, computers, which require analysis from experts, and that takes time. And normally, if you're on police bail, the police will quickly run out of time because of the sheer length of the inquiry. So that's most probably why she's been released under investigation. It also allows the investigating authority greater amount of time to conduct their inquiry.
So really what we're saying here is it's a strategic move by the police, so they're not on the clock.
Exactly right. Yeah, it can be seen that way. Yes.
I have a question here from Darren, and he asks, I was released under investigation in September 2019. Since then, it has been silent. How long can they keep me waiting? It's making me ill. I think this is the million-dollar question, because so many people are asking me this question. It's the most common question, actually. Nick, what's the answer to this?
Well, there are two parts to this, isn't it? One is that it's been quite a while for him, 18 months or so, where he's been under investigation. And the other part is that he's heard nothing about it during that period. So there are two issues. First of all, can that lengthy period of investigation continue without any real review? And the answer is, I think, yes, it can. And it could go on for a lot longer. It'll rather depend what the nature of the investigation is and what he is suspected of having done. That he has heard nothing or it's been silent. There may be an explanation for that. But the only way of finding that out is either to get his solicitor, if he's got a solicitor, and if he hasn't, he should get one. If he hasn't got a solicitor, get your solicitor and get the solicitor to speak to the investigators and find out what the progress is. If he doesn't want a solicitor and he wants to represent himself, and everybody's entitled to do that, then he would need himself to ring the investigator and find out what's going on. But when you're released under investigation, in a sense, you're going to have to be a bit more proactive about your position, either through the use of your solicitor or yourself, than would otherwise be the case if you were released on bail, where there would be information and there would be a review process.
The end of the road, Dean, oddly enough, is you will either receive in the post a postal requisition summoning you to go to court, or a notification telling you you're no longer going to be investigated and you've been refused charge and no further action is going to be taken against you.
Yeah.
Some of the communications I've received are from people saying, actually, they've been released under investigation for quite a number of years. Can the police just forget to contact you, especially if you've got no solicitor, or does that happen or not happen?
I don't think it happens on a regular basis. That's why most suspects have got legal representation, because the lawyer knows how often to contact the officer. For example, the officer may say, we've got to send the mobile phone off. That could take 3 or 4 months. So there's little point the lawyer contacting the officer after week 3 or week 4. You're going to wait 3 or 4 months, then speak to the officer, then update your client. I think the importance is making sure that the suspect knows what's going on. That's where the problem is. If a suspect believes no one's thinking about it, or doesn't know what's happening with the investigation, that's when frustration comes on the part of the suspect. So lengthy investigations, normally the officer and the lawyer will be in contact, and they will know roughly what the time scale is, and that will be relayed back to the suspect.
Do the police have any obligation to prove there's an ongoing investigation?
Well, the police, the police, well, let's just deal with two things. First of all, the police don't forget that they're investigating you, because the police officer in the case will himself be being reviewed, and the progress of the case that he's investigating will be being reviewed by more senior officers than him on a periodic basis. So the answer to that part is that the ongoing nature of an investigation will be reviewed within the investigator's own authority. As for the second part of your question, which is there a duty on the investigator to let the person being investigated know what the score is? That's less clear. If he's in contact with the solicitor, then usually for the cooperation of the solicitor and the defense, the officer will let the solicitor know of any important stages that have been reached within an investigation that may require the accused person or the suspect to come back and answer questions, or to be available to receive charges. Where postal requisition is sent, for instance, a postal requisition will be sent to the last known address of a suspect, and if he doesn't happen to be there or doesn't answer the requisition, then he could suddenly find himself being arrested, and all the ramifications of that. So there's usually a degree of cooperation between the solicitors working for the suspect and the investigators themselves. I suspect that's the position that you're aware of more than me, Simon.
Yeah, that's correct. Yeah.
So of course, some people don't have representation, don't have a solicitor, but I think what I'm getting from this is that it's actually quite important that you do have one. And if you're currently watching this, you're released under investigation, you don't have a solicitor, perhaps you ought to get one. Is that a fair comment?
Well, it always used to be said that a man that represents himself has a fool for a client.
Yeah, but it's a very true statement.
The other way is, would you ever consider conducting open heart surgery on yourself? The answer is no. So it's just go to an expert or a specialist criminal lawyer.
I mean, to be fair, if you're accused of a crime, it's very difficult to remain aloof from, or if you like, objective about the position that you're in, and it's useful to have a professional advisor who can say, now look, I know you feel like this, but there is that to consider as well.
That's a fair comment.
And
I have a question here from Eric, and he asks, I was released under investigation nearly 3 years ago. I had to disclose this to my employer as it has an impact on my job. My employer has now informed me that if I am still in this position by June, I assume he means June this year, my employment will be terminated. What can I do? Now, putting aside the employment law aspect of this, because I think there is one, Simon, is there anything he can do? Will this give him any kind of excuse to go back to the police, and will they listen?
Well, it seems an awfully long time, 3 years, which means it's quite a complex investigation. What he could do again, if he's got legal representation, is to get those who he has instructed to be in contact with the officer to find out what the problem is, and if they are going to be concluding their investigation sooner rather than later. It depends how he is with his employer, whether he can be frank with them and tell them exactly where he stands with the investigation. But I think there's more issues than the criminal investigation, which he's got a problem with. As you say, it's more of an employment law problem.
So just because he may well lose his job, that will not be something which the police take account of and think, well, we better get moving with this. It's not going to make any difference.
No, many suspects have unfortunately either lost their jobs, become bankrupt. The emotional turmoil it puts on being a suspect is great, and unfortunately people do lose their employment. Some can lose their homes, their families break up, the pressure can cause divorces, and it can be a great toll on being a suspect.
And Nick, lots of people have also been asking me, is there any route of appeal in relation to release under investigation? So if you've been, if you're kept hanging on for, in this case, 3 years, or in other cases I've seen 4 or 5 years, is there anyone you can complain to?
I don't know is the answer to that. Essentially, there isn't really a provision for an appeal process, other than, I suppose, judicial review, which is a slightly different legal remedy, and not one that I'm really qualified to deal with. But in terms of the Bail Act and the Police and Sentencing Act that we've been looking at today, there's no provision there for release under investigation to be reviewed as such. But it's not in the interests of the investigators either to keep an investigation dragging on for no good reason. There are very often a number of things attached to it. In the longer investigations, where release under investigation can be for many years, these tend to be financial misconduct and associated types of offences that are being investigated. And there's very often attached to that restraint, financial restraint, where people's assets are also restrained at the same time as they're released under investigation. And this is the operation of the Proceeds of Crime Act and various other important public policy areas of law that are designed to preserve, if you like, criminal proceeds where assets are suspected to be the proceeds of crime. So where all of those things are applicable, there do tend to be reviews, and where there is restraint, for instance, there's the opportunity to have the restraint reviewed periodically by the court that's granted the order. Many people who are in that situation will be restrained financially for quite a period, often for years, but there will come a time where the court will intervene and lift the restraint or amend the restraint to release either assets or funds.
I have a question here from Frank. He says, I am currently released under investigation, not bail. The police kept my laptop and 2 mobile phones. Can they keep my property if I'm not on bail? And if so, for how long? Simon, what's the answer to that?
The answer is yes, the police can retain those items. They were most probably seized, and those items would now be examined by an expert. What he could do is that he could ask for a copy of his computer hard drive, for example. So if it's got working documents and he needs it for work, then they may well give him a mirror copy. Of course, if he is charged with an offence, then those items will become exhibits in any case. So they will be retained, but then hopefully returned to him after or at the conclusion of the case.
So Nick, this doesn't sound very satisfactory, this area of law. It sounds like it's full of problems. You can be released under investigation pretty much forever. I know it probably wouldn't last forever, but you could be. Is it time for reform, in your opinion?
Well, the law is always laws should always be reviewed to see whether they're still serviceable or applicable. Release under investigation is relatively new as a concept, as we've already discussed, and since 2017 has increasingly been used to prolong investigations, if you like, into criminal conduct. The lack of any ability to review, certainly either in the Crown Court or indeed in the magistrates, depending on whatever power might otherwise be granted, the lack of any independent review from a tribunal of the status of being released under investigation, I think it is a concern. It'll need to be tackled at some stage, because release under investigation, I'm afraid, is now also, I think, a means by which the existing backlog of work in the criminal courts is being kept at a lower level. If cases where investigations were being diligently pursued were brought to charge and then charged, I fear the backlog of cases in the system would grow. Once a case comes to court, once a case has been charged, there are time limits imposed on the prosecution and indeed the defense, but on the prosecution in getting the thing to trial and in proceeding diligently. Witnesses, victims of crime, those who feel that they are victims of crime, even if in due course they're not seen to be victims of crime, but all these people feel disadvantaged by the process of release under investigation and the slow process by which offences now are being investigated. So I think there is probably the need for a political discussion, certainly, or at a higher level anyway, in Parliament or something like that, to move things along. It can't go on forever like this. It's just unsatisfactory. It's a no man's land at the moment.
Simon, last word to you. What's the most important advice you give to your clients when they're on bail or released under investigation?
Stay in contact.
And actually, you can see that from the questions, because many people are saying they don't know what's going on, and perhaps that's just because they're not doing that. So it seems to me that's really good advice. Thanks very much for watching. I hope you found it useful. Do subscribe to the channel. Lots more interesting and useful legal guides coming up, and are there already. You can also hear me on LBC Radio every Friday at 9 PM. And if you want to listen to podcasts, I have one called Celebrity Consumer and a new podcast coming very soon.